to the 55 Redefined podcast. Join us as we chat to experts and bring you tailored advice and insights to help you live your most fulfilled lives. We also showcase the stories of entrepreneurs, leaders, creatives, philanthropists, scientists, lobbyists, and everyday people who all, after the age of 55, are living their most dynamic lives and making their biggest impact. Hi, Georgina. It's fantastic to have you joining us here today for this podcast, looking at the big topic of divorce. It's a topic that is at the heart of our members, and I'm going to get into some of those statistics at a moment, but it would be great before we do so if you could just introduce yourself and your role at Slater and Gordon.
Hello, Lyndsey. Great to be with you. My name is Georgina Chase, and I am Head of Practice for the National Slater and Gordon family team. I'm a qualified solicitor with 10 years post-qualification experience, and I manage the family team with our main offerings in Manchester and our London teams.
You were recently covered by the BBC, actually, I saw, and quite a lot of radio coverage because of a prediction that you'd made about the fact that you're expecting a post-lockdown divorce boom. Can you tell us a little bit more about that?
That's correct, Lyndsey. So we have seen a rise in divorce inquiries following the lockdown, and obviously the pressure cooker environment that sadly that has placed on many couples, whether they be married or not. It has been a real stressful time with having to stay indoors, homeschooling, working from home. We've really seen the rise in inquiries. Whilst some people have been furloughed, unfortunately, it's meant for many that it's just really caused breakdowns in their relationships. And actually, there's been a troubling time for people to actually get legal advice because they've been cooped up in the same property. So often they've used the excuse of going to walk the dog to be able to try and ring their lawyer to get some more advice. It's been a very, very difficult time for people, but it's not all doom and gloom. I think, it's always good to see the positives as well, which is for a lot of couples, it's brought people together. They've had time together that they would never have had, and time seeing their children grow up that they would never have had previously. They've been able to watch, box sets together and work from home and really spend that quality time. So for many, it has actually improved their relationships as well.
We're obviously focusing on the 55 plus demographic, and there's some very interesting statistics coming out. So whereas divorce is generally on the decline in most age groups, it's got quite a peak in increase in the over 55 category. Interesting, I like your point really on the more positive side. There's also an increase in marriages over 55, over 65, and the narrative around that is generally around the fact that with the longevity of lives, people are living longer, and so they are reassessing their options for the next phase of their life rather than just accepting the status quo that they've had up until then. From the conversations you've had with your clients, Georgina, do you think that there is any particular reason that you've heard from your clients and conversations around why divorce isn't on the increase for this particular age group?
I would say that from my experience of speaking to clients, many feel that they've simply, sadly, grown apart after a long time together. I think outlooks on life do change, and if children have left home, they're classed as the empty nesters. They've potentially reached financial stability and they want to pursue new interests. And that can all change their perspective on life. I think for many, their goals and ambitions change. So for some, they want to travel the world. But if the other party just wants to stay at home and watch the television or play Sudoku, obviously that's going to cause some stresses in that relationship. I think the longer life expectancy as well has meant that more people are now working over the age of 60 than ever before. So it's likely that people can sustain themselves financially outside of marriage. And boredom, really, on the surface, everything seems fine, but people are feeling like they've lived the same life for many years. They've felt the same, they've dressed the same, they've had the same routine. And often when somebody new comes into their life, it's some sort of spark that means that they want to feel younger and reverse time for them. And it could be that people feel also that their perception towards divorce has changed. So I think that there's a reduced stigma around actually getting divorced. People feel life is too short. Why stay in an unhappy marriage when there might be a happier life elsewhere? So I think it's really the fact that life is too short. COVID's brought a feeling of, I want to grasp life with both hands, and potentially couples have just grown apart.
And so do you think in that situation where people have just grown apart, there is such a thing as an amicable divorce?
Well, firstly, no case is ever the same. So I have a mixture of clients who are very amicable and some that have challenges and struggle to reach an agreement outside of court or outside of solicitors' involvement. But the answer to your question is yes, it's very much possible to have an amicable divorce. And divorce doesn't always have to be a fight. My advice to anybody listening would be, make sure you inform your solicitor from the outset that you want your divorce to be dealt with as amicably as possible, because the solicitor, even in the very first letter, can set the tone. I often advise my clients to always keep lines of communication open with their spouse going through the process, because that will help with the potential of agreeing on certain things that otherwise will involve costly letters if you can't agree. So if a divorce itself is uncontested, undefended, i.e. not disputed by the other spouse, which is the usual way in this country, usually most divorces are undefended, it means it costs a lot less, so a lot less legal fees. It obviously takes a lot less time, and it doesn't require any court hearings. So usually it would be done by way of a paper procedure. Also, you can come to an amicable agreement in relation to the division of the financial assets in the divorce. Some couples may have obviously just grown apart in terms of in the marital sense, but they're happy to remain friends. And you've got to think about children and grandchildren, and the effect that having a contested or a very unfriendly divorce will have on the family as a whole. Spending thousands on divorce may also eat into the retirement fund or the savings that clients have worked very hard to accrue. And naturally at that age, spouses won't have a lot of time to recover financially. So I would always encourage everybody, think twice before you want your solicitor to send that nasty letter. And where is it going to take you? It is better to try and focus on getting through the process as amicably as possible, because that means as cost effectively and as quickly as possible.
We get quite a lot of anecdotal feedback through our members of mid to late 50s, early 60s women that have gone through divorce that are finding themselves for the first time having to really go back to work. So, they perhaps had an early career in their 20s, they left that to bring up the family. They've then gone through divorce. And it seems that the typical settlement is that the woman gets the house and the man gets the pension and some of the savings. And everybody thinks that that's a good deal until obviously they wake up to the reality that their house doesn't pay their bills or give them an income to go on holiday. And they have this terrible opportunity to either sell their property or actually go back to work for the first time in 20, 30 years to actually create an income for their retirement. Do you see that come about? And why do you think it, is that women generally get the physical asset rather than, say, the pension and the income assets?
I wouldn't agree with that trend, actually, because no case is the same. The law in relation to the Matrimonial Causes Act is a law of discretion. There are no rules regarding how assets should be divided. And if you had the same set of facts before a matrimonial judge, each judge would probably order a slightly different settlement, but the key is it would be within the same range. So how a matrimonial case is resolved by the court is that when you apply to the court for financial remedy, it involves the court assessing the case against the factors which are included in Section 25 of the Matrimonial Causes Act. And all of the factors are seen as equally important, but the judge also must consider the needs of the parties and those of the children. So the first consideration will be rehousing. But the court will also say, well, if keeping the wife in a property which is in excess of her needs, that might result in the court ordering a sale of the property and for the wife to downsize to be able to then purchase a property mortgage free so she can meet her needs. I think it's very easy for when you're listening to other people and what happened in their divorces to say, well, that must happen in mine. But every case is decided entirely on its own merits. And there's so many factors that are taken into account, including, as you've highlighted, income capacity, whether parties are close to retirement, their financial needs, obligations of both spouses, not just one, the standard of living enjoyed during the marriage, the age of each spouse, any physical, mental disability, the contributions, conduct, although conduct is usually in relation to financial misconduct, and that's very rare as a factor that the court can take into account. And the value to each spouse of any benefit that they potentially would lose the chance to acquire upon divorce. So there's no one size fits all. And I think people have got to be very careful to assume that there are set rules. Every case is different. And that's why it's so important that you get the independent legal advice, so your solicitors can guide you as to what would be the appropriate settlement if you were before the court in financial remedy proceedings, and you can try and negotiate to reach an agreement based on that guidance.
So it sounds like, Georgina, that you hear quite a few myths that you probably have to debunk on a regular basis about, do I get the house if I'm not married, for example, or am I entitled to a pension? What are the most common myths that you think the public perceive about divorce, and what's the truth around those areas?
Yes, dispelling the myths is quite satisfying, actually, because there are so many myths out there. I think people talk to each other and just assume that means it's the law, but not at all. I think there's a big myth around adultery. People think that if you are married but you're already separated, having sexual intercourse with someone isn't adultery with somebody of the opposite sex, but actually it is. And people don't realise that is still adultery, even if you're separated. It can be cited as adultery in a divorce petition. People also think that adultery has an impact on the division of the financial assets. That's actually not true. The overall ground for a divorce in England and Wales is that the marriage is irretrievably broken down. Adultery is one of 5 facts that can be used to establish this. However, adultery will not have an effect on the division of the matrimonial assets. So a respondent to an adultery petition will not be penalised in the financial settlement. And you can imagine many petitioners to an adultery petition would find that very unfair. Yeah, exactly. Yeah. And it's one of those things that you have to inform clients of in the very initial appointment, because you've got to choose wisely which fact you're going to rely on. And adultery generally can only proceed where the respondent will consent to the adultery, because otherwise that petitioner has to try and prove that adultery has taken place. So that's probably the first main one around adultery. The second myth: if the former matrimonial home is owned in one spouse's sole name, the other spouse has no rights to the property. Again, that's simply untrue. A spouse has a right to occupy, and the former matrimonial home will be considered as a matrimonial asset for sharing upon divorce, regardless if it's owned in one party's sole name. If the property is owned only in one spouse's sole name, the spouse who doesn't have an interest in that property, if the name is not on the land registry title deeds for that property, then they will be advised by their solicitor to immediately, this is standard practice, register what's called a matrimonial home rights notice on the title to protect the interest and to protect the other spouse dealing with that property without agreement, given that it obviously should be shared within the divorce settlement. And that's not to be seen as a hostile step. That would be the advice that any solicitor would give to a spouse whereby they are not named on the legal title of the former matrimonial home. Another classic myth is my pension won't be taken into account. Again, untrue. A pension claim is one of the 3 main financial claims upon divorce. And a pension can be a very significant and valuable asset of the marriage, which can certainly be taken into account within an overall financial settlement. A number of factors will be taken into account when considering whether a spouse is entitled to a share of the pension, and if so, the extent of the share, such as the value, the nature of the pension, whether the other spouse has any pension provision, the amount of pensionable service accrued during the marriage. So pensions are very much taken into account.
Given the demographic of our group and the availability to start drawing on pensions from 55 and beyond, it could be quite the case that we have members in their 60s or their 70s that are undertaking divorce, where they are jointly but living off of the income from just one person's pension within that marriage. How catastrophic or workable is it in that situation where that pension is divided and they are perhaps in their late 60s, mid 70s? How do you see that impact people financially when they're splitting that income, but then their cost bases are doubling in effect as they've then got two properties to serve? Do you see that people have to go back to work, or do you see that it actually changes people's minds about whether to financially separate in the first place?
I think it can be a bit of a reality check in terms of when usually you would get an expert to prepare a pension report based on the pension claims upon divorce, called a PODE, Pensions on Divorce Expert. And given for the over 55s, obviously the pension is usually a significant pension fund has been accumulated. Evidence from a pensions on divorce expert is likely to be imperative. And what the pensions on divorce expert will do is they will go through what the likely pension claim will be and how that will then affect that individual's pension. And that does take into account the other spouse's pension. But usually where one spouse has a more significant pension than the other, it would be that pension that would be shared to equalise the position, to equalise incomes upon retirement. And what's called a pension sharing order is how a pension claim is dealt with upon divorce. And that will have the effect, if the pension is already in payment, of immediately reducing the pension by the percentage of the pension sharing order. So as you've highlighted, that could affect significantly the income that somebody is left with. And that would mean that they would also then need a fair share of the capital division in addition, because their pension sharing order that will be subject to their pension will obviously have that significant hit. So I always advise clients to make sure that they get financial advice, independent financial advice, alongside considering their financial settlement upon divorce, so that they can consider the best plan for them. Obviously tax advice is obviously extremely vital in these scenarios. As lawyers, that's not something we can offer. So it's very important to have access to the best experts at the solicitor's fingertips of whoever you're going to instruct, because you need to consider your future financial position very carefully to secure as much security as you possibly can, with the fact that divorce after a long marriage is going to be the sharing, and the starting point is 50-50. It's
one that we like, obviously we've partnered with yourself on the legal side. Our financial planning partners are all SOLA accredited, so the Society of Later Life Advisors, and whoever our members use, I would again recommend that they have that SOLA accreditation, so that they are experts in that later life and pensions division, rather than if you're dealing with divorce with somebody in their 20s and 30s, it's a very, very different experience to if you're in your 50s, 60s or 70s, and it's more complicated to separate those assets out. With some of those kind of financial challenges, what do you see on the more positive side of opportunities? So you read in the paper about people having divorce parties, and this is like the next phase of their life where they're just dead excited about what they can do and where they're going to travel and how they're going to live. Is that been your experience? So have you been parties that are genuinely not just amicable, but really pleased about moving forward, and how they've kind of partnered with each other through the divorce process?
Yes, I have had some lovely experiences whereby I've been able to sort of guide a client through a divorce situation. They have been very amicable with their spouse. We have obtained the decree absolute. We've obtained the financial consent order to formally dismiss the financial claims and make their settlement legally binding. They've moved on with their lives. They've met somebody new. They're still friendly with their ex-spouse. Potentially they have children or grandchildren together. It's a time for people to feel free, to feel they've got a newfound freedom. They are living a new life, and full of energy, but still divorce hasn't been the worst thing in the world that they've been through. That's obviously, one person may have experienced an amicable divorce, and at another feels that it was the worst time in their life. I think it is, potentially helping somebody going through what could be the worst time. It is an extremely stressful process, but not in every case. Every case is entirely different. And you do have those cases whereby people are able to reach an agreement direct between themselves. They each keep their own pensions. They've both got either no pension provision or very little, or they've got significant pension provision, but each of them have, and therefore they say, well, we'll just keep our own. They split the property 50-50.
Yeah.
They have a clean break, no ongoing spousal maintenance. And they are happy that they've been able to achieve a settlement which has been relatively straightforward and amicable. And as long as they've been advised to get that financial consent order, as well as the decree absolute on divorce, which is absolutely key, they are satisfied that they've gone through the process as smoothly as possible. I've never been invited to a divorce party, unfortunately, but I do know my
members,
clients.
we're calling out to you to send Georgina our first invite.
That's it. I do know that the champagne bottles are certainly out, and the corks are popping once the decree absolute and the financial consent order has been approved and implemented. And I receive lovely emails from my clients, if not months or years later, with photos of how happy they are now, and they're on a beach somewhere walking their dog, and they're pleased that that part of their life is done. And it's nice. I stay in touch with some of my clients because it is you are going through such a personal journey with them. It's lovely that you see them come out the other end of what is a very stressful time, but something to get them through it as smoothly as possible.
What role do you think the solicitor has to play in facilitating this more amicable route? And do you think that you're the exception to the rule, or do you think actually that this is another myth that needs debunking, and actually pretty much all family law solicitors are there to get the best and most affordable result for their clients?
I would say a lot of family solicitors in this country are members of what's called Resolution, which our family lawyers at Slater and Gordon are, which is we are committed to a non-confrontational approach when it comes to dealing with family law issues for our clients, and to try and resolve those in an amicable way, working cooperatively with our solicitor opponents. Being prepared to pick up the phone rather than writing correspondence, which obviously can only inflame matters in some respects. We pride ourselves on making sure that we provide our clients with the opportunity to reach an agreement amicably within an initial client appointment. One of the first questions we ask is, are you definitely ready for divorce? Because often clients are just not ready. They want to come to us. They may have had an initial conversation with their spouse. They feel that the separation is on the cards, but it's more an information gathering exercise. And I say, well, if I don't hear from you again, I wish you all the best. But you should try some marriage counselling. Only come to me when you're absolutely ready to press that divorce button. But some aren't ready for that, and it may be that I don't hear from them again. I think within the initial appointment, it's very important to explain to clients that if they want a nasty, contentious divorce, then it's going to take longer and cost them a lot more money. It's about giving clients the option and explaining that whilst we will obviously always act on their instructions, it is possible to have that amicable divorce. And I think once you give a client the information regarding how the process and procedure works and the likely cost estimates, if it does go all the way to court or all the way to a contested final hearing, it really does put it into perspective. So it's then up to the client to decide, well, are they going to try and reach an agreement amicably? Are they going to potentially attempt mediation? Or are they going to try and work with their solicitors outside of court to reach an amicable settlement once they've had the advice that they potentially need before they can do that, as to what the court would say would represent a fair settlement upon divorce, with obtaining the expert reports that might be needed, such as evaluation of a business or evaluation of a pension, but still being able to do it as amicably as possible rather than it have to be a battle. Court's always seen as a last resort, and there are so many alternative methods to resolve the dispute that are now available to clients. And we go through those within the initial appointment and give realistic cost estimates and realistic time estimates. So I'd say to anybody, if you are having to go through this process, make sure that you have that initial consultation with your solicitor. I always say be aware of the DIY divorce online cheapest chips sites, because you get what you pay for. And I think what people don't realise when they're trying to go online and obtain a divorce as cheaply as possible is the divorce is connected to the finances. So getting divorced, going straight to getting decree absolute, which dissolves the marriage, does not actually resolve the financial aspects of the divorce. So you can have clients that can reach a financial agreement verbally, but unless you've got that drafted by a solicitor into what's called a financial consent order, which is lodged at court once you're at the first stage of the divorce, the decree nisi, until that consent order is approved and sealed by the court, that settlement is not legally binding, and financial claims upon divorce simply remain open. And nobody wants to finish their divorce thinking we're all done, and then in years to come, their ex-spouse comes out of the woodwork and says, actually, I didn't make a claim on your pension and now I want to make one. And technically they could do, because you haven't dismissed the claims formally by entering into that financial consent order. But when you're going through those processes online, you don't get that advice that you would get from a solicitor. So it's very important to get that initial advice so that you know how the process works, what you are expected to pay, how long it's going to take, and have those conversations, and then you can make an informed decision.
So you talked a lot in that last piece, Georgina, about the importance of that early consultation process. And I think people are quite cost-minded, as you say, when they're at that fact-finding stage, about not racking up early bills before they have decided. And how much would people need to budget to set aside to have a thorough initial consultation as part of their fact-finding?
Well, at Slater and Gordon, we offer a reduced fixed fee initial consultation, which is £250 inclusive of VAT for 1 hour. And within that initial consultation, we will obviously go through the client's circumstances. We will get more information in relation to the client's wants and needs. We will go through the divorce, the law, practice and procedure, and cost estimates. We will go through the finances, how to resolve the financial aspects of the divorce, the process, the procedure, and cost estimates. And we will then get an action plan for next steps if the client wanted to formally instruct. I would say that firstly, picking the right solicitor for you is absolutely crucial. You need a solicitor that you feel is going to fight your corner when needed. You need a solicitor that's going to not be too busy to be able to communicate with you. Obviously, going through a stressful time, it's very important that you feel that you have that immediate access to your lawyer. And you need to feel that you are instructing a solicitor who understands and who will always present your case in the best possible way, but also give you realistic advice and realise your expectations regarding what it is worth fighting over and what actually should be done by way of agreement to save legal fees. So it's having somebody on your side, and you can only really gather whether that solicitor is right for you by having that initial consultation and getting a feel for that solicitor, and a feel for how that solicitor will then manage your case moving forward. If you are wanting to ensure that the divorce is dealt with as amicably as possible, that your solicitor knows that from the start, so that any correspondence sent sets the right tone from the beginning. And I think that's obviously really important, especially when some solicitors can create more hot air than is needed when writing correspondence. Certainly, when I send my clients an initial letter to the other spouse, it would always be in draft first for them to very much consider it, to make sure that the wording is as amicable as possible, because that spouse is going to take that letter to their solicitor, and obviously that then sets the scene as to how the divorce will progress. So very important you have a solicitor that's going to listen to you, and as I say, fight your corner when needed, but also make sure that they're able to progress matters as soon as possible for you, as soon as practically possible, because at the moment we are subject, all solicitors across the country are subject to court delays, unfortunately, due to COVID. Divorces are taking longer, and we are seeing that there are a backlog within the court system in dealing with financial consent orders to be approved, or financial remedy cases that are in court. Hearings are being listed later and later because the courts have got so many hearings before them. So again, it all points the client in the direction if you can try and reach an agreement outside of court, it really will be a saver for you of time. But the general time estimate that I'm giving to my clients at the moment, taking into account the court delays for a divorce, straightforward divorce, undefended, usually now between 6 to 8 months. That's how long it's taking. And that's not the parties or the solicitors. That's because there is a hold up with the court. So if you are going to go down the divorce route and you want to get out the other side as soon as possible, it's obviously better to start that process sooner rather than later. I should also flag up that we have in April 2022 now the introduction of no fault divorce. So this was due to be introduced in autumn 2021. But we found out last month that it's been now delayed to come in April 2022. And it's the government's Divorce, Dissolution and Separation Act 2020, which will reform the divorce process to remove entirely the concept of fault. So the Act was passed in June 2020, and the government is currently working on the implementation of the changes. The new legislation will replace the 5 facts, which currently a petitioner has to rely on one of those 5 facts to prove to the court that the marriage is irretrievably broken down. And that will be replaced, the 5 facts will be replaced with a new requirement to provide what's called a statement of irretrievable breakdown. So it will remove the possibility of contesting the divorce. And it will introduce an option for a joint application. And it will ensure that the language in the divorce documentation is more in plain English. So it's going to be very, very much a new dawn for divorce. And I think we're going to see more people feeling more comfortable with getting divorce on the basis that they're not going to have to rely on the fault-based fact of either unreasonable behaviour or adultery, which they're currently having to rely on in order to get divorced unless they've been separated for 2 years or more.
And particularly, as you say, for the type of demographic in our audience, I think the more common reason is that people have just grown apart. And so, you don't, you're friendly, you've spent a big part of your life with that person. You don't want to say they were adulterous when they weren't, or have to kind of put blame, because that sets the tone, as you say, right from the outset, that someone is at fault, when actually sometimes no one is at fault and you have just grown apart. So interestingly, do you think that there's going to be quite an uptake in applications post-April? And do you think the situation will ever come about, Georgina, where for that initial consultation, you'll get both parties come to you together rather than just, one spouse or the other looking at their own personal position?
Well, firstly, yes, it will increase the divorce rate, I think, because it's going to be a lot easier to get divorced. The financial aspects of the divorce still need to be resolved, which is the more complex area. And as I say, it's absolutely vital to enter into a financial consent order alongside your divorce, because the divorce only legally ends the marriage, doesn't resolve the financial aspects of the marriage. But in relation to both parties coming to me, that wouldn't be allowed because there'd be a conflict of interest. So one spouse, however amicable they are with their spouse, the other spouse would have to make sure they go and get an alternative solicitor. But obviously, I would work with that other party solicitors to ensure that the divorce is progressed as smoothly as possible. And yes, at the moment, as the law stands, unless you've been separated for 2 years or more, and the respondent consents to the fact that you've been separated for 2 years or more, if a petitioner wants to present a divorce petition to the court, they have to rely on either unreasonable behaviour, which is usually half a dozen examples of the respondent's unreasonable behaviour, how it made them feel, or adultery. And I have lots of clients saying to me, I really do not want to have to put examples of my husband or wife's unreasonable behaviour in the divorce petition. And it's a real challenge. And I give examples to my clients that obviously, I'm sure in any relationship, married or not, we all could think of examples of the other party's unreasonable behaviour, which can be such things as leaving the dirty dishes in the sink, not switching lights off when leaving a room, leaving dirty socks around, and over time, if the judge felt that that was something that would actually really irritate somebody, that could be classed as an unreasonable behaviour example. So they don't have to be the most hostile examples in the world, but equally, you have to have them strong enough to prove that the marriage is irretrievably broken down because of those. And it is really challenging when people want to keep things as amicable as possible. So when I said previously about keeping those lines of communication open within an initial appointment with my client, if they are wanting to be the petitioner and present the divorce petition to the court, I will say to them, well, show your spouse, your wife, your husband, a copy of the proposed unreasonable behaviour particulars before you send them to me, so that if there's anything there that they particularly take issue with, you could maybe amend and replace with something else. But unfortunately, in order to get divorced now, if there's no adultery involved, it has to be unreasonable behaviour. And those examples have to be provided. I also say that it's not worth waiting, because the longer you wait to get divorced, the longer you're waiting to sort finances out. And it's very important for your listeners to understand that when you look at resolving the financial aspects of the divorce, the financial circumstances of you both at the time you're going through the divorce will be the ones that are considered by the solicitors and the court potentially, as opposed to the financial circumstances that you had upon separation. So it's actually best not to wait. If the marriage is irretrievably broken down, it is best to sort the finances out at the same time as sorting the divorce out, rather than waiting, because things may have changed significantly if you wanted to say, well, I'll wait for the 2 years until we can separate after 2 years in separation. But obviously pension values will have changed significantly. And whilst you can try and accommodate that within the financial settlement, it does make it more complicated. So it is better to sort the finances out at the same time as the divorce, and don't delay on the divorce if the marriage is irretrievably broken down for those reasons.
And then just a couple of questions really that we hear a lot, really, given the sign of the times that we're now in a post-pandemic world where obviously before COVID, we're going to have like BC, aren't we, and AD. So before COVID, people would have been having these consultations with you, I'm sure, face to face. Are you finding now that video is an option and has become mainstream, that people, are not precious about coming and meeting you in person, and they are happy to come and talk to you over a video link, and that might be the only way that you ever engage with them, and you never actually meet them in person? Is that the way forward, you think, for this type of legal support?
I think with family law, it's so personal. There will always be the clients that want to have the face-to-face appointment with the solicitor. And that's something that we will always offer, of course. However, there are the tech-savvy clients that are quite happy to have an appointment via a video link, Teams or Zoom, which is obviously what we're offering at the moment, or a telephone appointment. Where those clients are very amicable and they are not turning into contested financial remedy proceedings cases, then actually it could be that I have that initial contact with my client on the Teams video or telephone. Yes, we have a few more meetings during the case, but actually most of our communication may be limited to email as well, unless those clients very much wanted to reach out and have more appointments. Obviously, we've got to be very considerate of costs. I think moving forward with Slater and Gordon for our staff, it's going to be very much working in what's called a hybrid model of connected working. So we will be working from home, but also working from the office. But it won't be Monday to Friday as it previously was. It'll be probably 2 days a week to make sure that we can cater to our clients and have those client meetings and have collaboration within our teams and work together on client cases as we do now. But the rest of the time, it will be flexible working with the use of tech, meaning that we're working in a more modern way. And again, we will cater to whatever the client needs in a particular case. Whether that's face-to-face, we can make that happen, whether they prefer a video or a telephone. And we've always been able to do that. We've always had a mixture because we've had clients from across the country nationally within the family team, because of the fact that we offer family law services nationally anyway. So I think whatever the client wants, we can accommodate.
Thank you so much for your time. I think for our listeners here today, I think the most likely scenario of people listening is that they are considering divorce. It is something that's in their mind. They've maybe undertaken separation or just not happy where they are. And I think you've given some phenomenal advice and some pointers to think through. And also that flag about the changes in legislation in April 22, which I think will really help people that are in that more amicable position of just, going their separate ways. So thank you so much for your time, Georgina. It's been fabulous talking to you, and we wish you all the very best.
Thank you very much, Lyndsey, and I wish all your listeners the very best as well.
We hope you've enjoyed this episode of the 55 Redefined podcast. Visit www.55redefined.com to discover inspiring stories, tailored advice, and motivating ideas. Join us on this journey to change the way the world views life after 55.